list has stabilized for the moment. So I want to thank everyone for joining us. I am Dr. Jedediah Cronky, a member of the faculty here at the University of Hong Kong, and I'm very happy as both as a contributor to welcome you to sort of our regional book launch for the Global South and Comparative Constitutional Law, a collection that was published earlier in this year, and to which I contributed, and to which we have a wide range of quite excellent commentators to give their thoughts on today. So the way in which we'll progress today is that we have the editors here joining us from Berlin, and Michael and Philip will give a brief sort of introduction to the project and their motivations. Then I'll give sort of as the local sort of contributor, a brief sort of summary of my contribution to the volume and some of the reasons that I was motivated to contribute to it. And then we'll move on to our four contributors who will give their thoughts. And then we'll move on to a question and answer session at the end, where we will look forward to everyone's questions. For those of you who have not had this particular format before, just remember that you can enter your questions in the Q&A section as well. If you have a very specific question for an individual commentator, feel free to put it there. They may or may not be able to answer it in real time. Otherwise, at the end, I will collect those questions after Michael and Philip have had a chance to respond, in which we'll spend the remainder of our time together. Okay. So without any further ado, Michael, why don't you sort of start things off for us?
Yes, thank you so much, Jed, for organizing this, to Hong Kong University for putting this up, and thank you to the commentators for taking the time and the energy to read the book and take the pains to comment and give you feedback. And I really look forward to the input that we're getting from you and continuing with this sort of intellectual project. So as by way of preface, I'd like to point out that this book is a collaborative effort, of course, and the main chapters have been written by authors who all hail from or are based in the Global South. So there is a diversity of opinion in the book, and here I speak only as one of the three editors, of course, and as one of the authors of the introduction. And from our side, from the editor side, the book is part of a much longer engagement with comparative constitutional law in a North-South perspective. The book emerged from the 50th anniversary conference of the journal that's now called World Comparative Law and used to be called Law and Politics in Asia, Africa, and Latin America, one of the few journals that has addressed legal developments in the Global South since 1968, this auspicious year. And since Philip and I have been among the co-editors for some time, from that perspective, we observed that there is a deficit in comparative constitutional law as a discipline to which this book responds, namely an underrepresentation of authors' experiences and perspectives from the Global South. And what I would like to do in the next sort of 5 to 7 minutes is that I'd like to make 3 points from the perspective of the introduction of the editors that we also make in the introduction of the volume. I'll first spell out the general argument, namely that there is and that there should be a Southern turn in comparative constitutional law. Secondly, I sketch how the notion of the Global South might capture a distinctive constitutional experience. And thirdly, I reflect on the implications of the Southern turn for comparative constitutional law more broadly. So what's the sort of argument of the book? It departs from the observation that there is this deficit that comparative constitutional law, while it has globalized considerably over the past 20 years, the US, Canada, Europe still remain the most studied jurisdictions. And most importantly, they still dominate the epistemic framework within which we study constitutionalism around the world. So while we've added new material from the South, we have not necessarily pluralized and equalized the epistemic and theoretical framework. And that's what we're trying to do. The argument for a Southern turn has 3 components. It first requires to take constitutional law in the Global South seriously and understand it on its own terms and not necessarily within the frameworks of US American or European constitutionalism. Second, it's to pluralize the framework of comparative con law from the perspective of the global south. That is, it's not an exercise in particularism or area studies, but it gives us an intellectual input for the broader discourse, for also looking and understanding constitutional law in Europe and North America. And we think that this argument is encapsulated by the notion of the global south, which to us inherits the emancipatory connotation of the third word. And so in that sense, the book is also an attempt to theorize the notion of the global south, which is often used without much reflection in the discourse. So in a way, you could say that this book is inspired to a certain extent by what Trail has done, third world approaches in international law in the 1990s, although there are, of course, differences as well. So the book makes various offers of how to proceed with this southern turn, and to that end, it's organized in two parts. We have a first part of 4 contributions that theorize the global south in comparative constitutional law, that look at the conceptual epistemic framework in which constitutional thinking has taken place. And the second part then features 7 chapters that develop important themes of constitutionalism in the South, such as transformative constitutionalism, access to justice, and authoritarianism. I'd like to emphasize that we, as the editors, have not sort of given the authors any particular sort of framework in advance of writing their chapters. They were sort of free to write from their own perspective. And what we've then done in the introduction is to sort of try to pull together some of the strings that we thought the chapters have in common. So this leads me to the second point in our argument that we mainly make in the introductory chapter that is co-authored by Philip Dunn, Maxime Bonnemann, and myself. And here we argue that the notion of the global south captures a distinctive constitutional experience that is shaped by a distinctive context and distinctive themes. So that there are 3 elements. First, the notion of the global south, then this context, and then the themes. To us, the notion of the global south is less a geographical notion and represents more a perspective from underrepresented jurisdictions and sections of society within jurisdictions. When we say that it's distinctive, we are deliberate in the use of distinctive rather than different, because we think that not all elements that are particularly salient in the South are exclusive to the South. So there may be a North in the South and a South in the North, of course. And there is, of course, a dialectical relationship between the two. Global emphasizes these entanglements and sometimes symbiosis. So there is no dichotomy and certainly no hierarchy that we're trying to put up here, and certainly we're not trying to essentialize either of the categories. So what is the shared and distinctive context that we think characterizes the South? So there is first of all the historical legacy of colonialism, which is very heterogeneous on the micro level, but we do think it has sufficient commonalities at the macro level, where the South generally is imagined or portrayed as the colonized and the North as the colonizer, if only at the discursive level. So there is a legacy in structures of racism, exploitation, and domination that lives on in contemporary inequalities and geopolitical asymmetries that we think still sort of characterize this North-South divide, despite all the sort of qualifications that you can put. Lastly, what are the distinctive themes? We argue we put up noted 3 of them in the book, but there may be others. The ones that we mention is that constitutionalism is envisaged as a vehicle of socio-economic transformation, and not just sort of as a limitation and legitimation of the sort of political system and political power. So in the face of persistent inequality, constitutions do not just aim at limited government, but at an active state, positive obligations, judicialized socioeconomic rights. And in my own research, what I look at is at maybe a particular form of economic constitutionalism, particular approach to transnational corporations, but that has still to be developed. Second distinctive theme, we termed constitutionalism as a site of struggle for political order that sort of oscillates between democratic and authoritarian tendencies. So in post-colonial states, the constitutions have to integrate deeply heterogeneous populations within colonial borders. And this occasioned experiments with multi-ethnic democracy and federalism, but also periods of authoritarianism and violent internal conflict. And finally, third theme, constitutions, is access to and denial of justice. This speaks to the profoundly ambivalent and sometimes contradictory nature of law and the state in the South, which are both an instrument of emancipation and oppression. So with that, I come to the last point. And the question, what is the significance of this Southern turn and Southern experience for comparative constitutional law more broadly? And here we think that taking this distinctive Southern experience seriously has implications for the entire discipline of comparative law. The South denotes an epistemic and methodological and institutional sensibility, a way of doing comparative constitutional law that's characterized by three elements, sort of epistemic reflexivity, methodological pluralism, and the need to reorganize and diversify the institutional system of research and intensify collaborations between North and South. What that means we can discuss. We elaborate on that in the chapter. What does epistemic reflexivity mean? What kind of methodological pluralism do we have in mind here? But I'd like to conclude it here and sort of just say to invite everyone to continue this debate today and afterwards, ideally by sort of also submitting articles to our journal that reflect on North-South relations and comparative constitutional law. So that this book is certainly not a one-off attempt, and it's certainly not perfect. And with that, I hand over to you.
Okay, great. Thank you, Michael. So very briefly, in talking about my contribution to the book, in many ways, some people may have detected I'm a bit of an interloper in the sense that I'm a contributor, but I'm definitively not from the Global South in an original sense. But I came to participate in the project in part because of not just my own scholarship, but at the time I was teaching in Brazil. And I've spent my sort of postdoctoral sort of life, academic life outside of the US, and long-term sort of my scholarship is focused on US-China relations. And I've come to think about some of these critiques being trained as an anthropologist from taking seriously the critiques as far as the West's, the North's, or however you want to conceptualize its engagement with the other, to something that I feel is often left out, which is how to really bring that critique home as an active academic and personal practice in the global North, as we sort of describe it here. So my chapter, which talks about legal innovation as a global public good, remaking comparative law as indigenization, reflects my thoughts and sort of having critiques, but then thinking about how to really make people aware of these critiques in a way that maybe appeals to some of sort of like the less sort of altruistic, less cosmopolitan sentiments that often predominate in day-to-day life. And so in that sense, I really try to frame these types of critiques as promoting a comparative law as a form of selfish learning, right? That has a very domestic orientation, right? And in its simplest terms, trying to get people, and especially coming from the United States originally, to see comparative law as a selfish exercise that has selfish domestic, purely domestic payoffs. And part of this, and again, if you read the chapter, you see it does very much take a definitive sort of stance that like what's called the functionalist, sort of more pragmatically oriented view within comparative law is the best one to proceed with, in part because the deep sort of sentiment, and here I try to focus on not just what comparative lawyers say, right? I often critique what we sort of say to each other at academic conferences and our sort of better angels, but what non-comparatives, right, lawyers sort of think about comparative law and think about this type of practice. And the idea, and one of these legacies of colonialism, is this idea that you can help others sort of cross-culturally through comparative law, right? This is sort of the humanitarian sentiment. And I think in my own work, I've come to sort of really sort of struggle whether there's any way to sort of redeem that type of perspective, right? If your primary way in which you've been socialized to think about legal information exchange and comparative law, right, as an exterior exercise, and that modifications and reactions to critique should primarily be conceptualized in how particular actors relate outside of their home societies, that this, that this creates some insurmountable problems, right? And so in the paper, I talk about how if you're really going to remake some of these practices in the sort of targets of critiques, whether they're the global north or even the global north in the global south, however, again, you want to put those things together, there's some sort of very sort of daily life type of things to think about how people relate to their home societies, and especially, again, how they relate to non-comparative lawyers. And so I think one of the things that I think a lot of us have participated in is because some of these markers and institutions of status are still disproportionately in the global north, some of those day-to-day practices have these sort of disproportionate network effects on how people think about comparative law, not just outside of those countries, but within them, right? So the article generally tries to make a pitch that people should think about comparative law as a national, domestically oriented exercise first, right? And not as something that involves sort of remodulations of how you engage with others, right? Even though that's still going to be part of the conversation, right? So in a very basic way, in my own work, I consistently, even though I write about China or sometimes I write about Brazil, I never do that with the intent that my writing is going to, promote or stimulate reforms in those countries, but with always the payoff that they're more radically, from my view, supposed to stimulate reforms and payoff within my home society, even as I teach outside of it. Okay. So that's just sort of a general pitch for the perspective in my contribution. And I think why I was particularly interested in working on this project is both in my time in China and Brazil, these ideas of sort of categories and post-coloniality, geography, and power have really been something I've been struggling with. Coming from anthropology, and particularly legal anthropology, the frame of what we call legal imperialism was the predominant one in which I was sort of brought up in, which is, again, this way of thinking about what the United States or Europe has done to other countries in colonial and other contexts. But in especially the US-China context, that never really seemed to completely fit, right, the dynamics that were involved. And, and it often became that when I engaged with Chinese interlocutors, right, they didn't necessarily see that as the frame through which those relationships were organized. So when I was in Brazil, it was interesting because that was the age of something that we haven't, which was the age of BRICS. Right. And I remember Brazil, Russia, India, China, and South Africa were sort of this residual category of places that people felt maybe didn't quite fit into a binary and had to have their own sort of form of organization. And, at the time in Brazil, it was seen as a developmental exemplar. And so it's sort of, there are a lot of conferences that sort of proudly trumpeted that. But during just the time I was in Brazil, that completely collapsed. I don't know if people still do BRICS conferences or BRICS framing, but I think first Russia, when it invaded Ukraine, disappeared out of BRICS. And then slowly everyone sort of, the BRICS sort of fell apart in that sense. But I think one of the other things that's really sort of made me think about this sense of geography and category is sort of this rise both in China, India, and other places, and in the US in certain terms, right, of sort of authoritarian regimes that grab onto some of these discursive binaries and use them for their own sort of repressive means, right? So if you look at contemporary discourse in Hong Kong and in Asia, and generally, the idea of sort of the Orientalist or colonial aggressor, right, is often used in a way not to really overturn some of those legacies, right, but as ways of legitimating quite authoritarian trends. And so while, as Michael outlined, people often try to say, well, when I say the global South, right, I don't mean a specific geography, right? I'm trying to talk about a project or historical legacy. And intellectually, I can understand that, but it makes me very uncomfortable sometimes because often public actors, right, and governmental actors don't recognize those distinctions, right, and are able to redeploy those in quite aggressive ways. And so, again, this gets to the point I mentioned earlier about the conversations that we're able to have with our better angels at academic conferences amongst ourselves, and then the reality, right, in politicized spaces of how those things get redeployed. And so in the end, they really make me wonder if when we think about the mobilization of power for sort of political ends, and when we're trying to produce and struggle to produce either nationally, domestically, or internationally, new types of solidarities to deal with some of these issues, whether this is sort of a trap whenever we have these binary constructions, right? They may be useful in some sort of academic sense, but when I think again about general politics, or even to think about what non-comparative lawyers in different contexts sort of reflexively grab onto, I wonder if there is ultimately any way of sort of rehabilitating that in a way where just focusing on things from a perspective of power or class or whatever other types of ways of reframing these things are effectively more useful. So I say that it's sort of in response to Michael, in the sense that I don't really use Global South or West or North or any of these types of things in my work. And I try to avoid that, in particular with the idea that I'm always thinking about how these terms are going to be potentially appropriated by other actors in other contexts. And I'm actively trying to sort of militate against that. Right? So again, that goes back again to my contribution in my chapter, which is again, trying to think about a way of making an argument to sort of reorient these things in spaces that are more sort of outside of what generally, comparative lawyers or people with these types of sentiments talk to each other about, but thinking about how they sort of resonate among just even non-comparative lawyers, which I think we have to admit are the vast majority of legal academics and lawyers still, but then in the political space, the political spaces beyond the academy. All right, so I think that's all the indulgence I'll take for myself as the local contributor, and leave the more interesting commentary to our invited guests. So with that being said, I think we are going in first name alphabetical order. We had a very democratic process at the beginning in which one person decided what the order was going to be. So Dinesha, I think we're going to lead off with your contribution if you're ready to go. And thank you very much for joining us.
Thank you, Derrida, and Michael also for the introduction. Let me also begin by thanking the Center for Comparative and Public Law to speak at this book launch. It's a good excuse to be amongst friends and colleagues, but also to contribute to what I think is perhaps a very important conversation in this field. So I've had the pleasure of interviewing Philip on this on the introduction to this volume last year, and we published that interview at the ISEL blog this July. And more recently, I have also had the opportunity to review the volume. So I feel like this edited volume has been a companion to my own intellectual journey in the last year. So in the most useful and productive way. For today's discussion, I have organized my thoughts under 5 points, and I go through them very quickly. The first is generally to locate the book in the field of comparative constitutional law, and also to say a little bit about what I think is my own bias coming into this conversation. The second is theoretical and draws from the first 3 chapters of the book in particular. The third is about the chapters taken as a whole and what I take to be 2 productive tensions that I see amongst these chapters. The fourth is about, again, my perception about the symbolic value of this volume in this particular moment in time. And the final, I think, final point affirms what Michael said about the intellectual agenda setting value of this volume. So let me begin with my first point. So I think, or rather I see this volume as a critical juncture in the field of comparative constitutional law. It is particularly so for individuals such as myself who have had a troubled and tense relationship with the field. But whether we see it that way or not, I'm prepared to argue that this book is a critical juncture for the field taken as a whole. But before I explain that, I think also need to qualify my view. I say this is a critical juncture, not because I think the volume is entirely new in its claims, although that claim could also be made. The volume represents a critical juncture because it mainstreams scholarly debates that have hitherto been peripheral to the field. With this volume, the hitherto nascent body of scholarship in comparative constitutional law that concerned itself with the global south, however understood, is able to claim its place in the broader mainstream intellectual debates about decolonizing the field of comparative constitutional law, but also take its place in the global intellectual debates we are having about the decolonizing of the pursuit of knowledge itself. Previous interventions, particularly those of James Tully, Maldonado, and Oklepich, were, I think, preparatory, while this volume is ground clearing. Now, I mean, to put it in very simple terms, now when I participate in a conference, there has to be scholarship from the Global South, or that there is a need to draw from the Global South as well in understanding the field as a whole. That work has been done. We just have to refer to this volume. So in that sense, we have come to an important juncture, and taken together, all this scholarship has established and validated a different, if not new, line of intellectual inquiry. And for that, I thank everyone concerned in this project. I think it's necessary to qualify my claim further. In arguing that this volume represents a critical juncture, I must also be self-critical of my own bias. Now, as Jedediah mentioned as well, in my work, I have almost always approached the discipline from my perspectives of my Sri Lankan experiences. Even though I have studied, worked, and lived elsewhere, I self-identify as an academic of and from the Global South. Now, I cannot help but notice that the turn to the South and the double turn that this volume calls for places me and others like me in a position of privilege. And I think if I'm not self-reflective of that, it can be problematic and perhaps even harmful for my own work. But going further and reflecting more broadly on the question of who can speak for the Global South and why, my current thinking has been influenced and encouraged by this volume. It seems to me that meaningful collaboration between institutions and scholars is a prerequisite. It's not an option. It's a prerequisite for developing robust scholarship in comparative constitutional law. And I hope we can discuss this further in the Q&A. So now to my second and third points, which are about the different chapters of the volume. I find the theoretical chapters of the book to be most useful in my own work and in the questions that I have, in seeking answers to the questions that I have. Now, today I will limit my remarks to the first of the 3 chapters, including the introduction. They are useful for me for the following reasons. As I already mentioned, they offer a long overdue corrective to the field in terms of how to think in an inclusive way at the epistemological level, not at the level of case studies. Second, I find the call for a southern and double turn to be compelling and true. Third, I am reassured as a scholar by the emphasis on the need for interdisciplinarity. We've had a lot of back and forth on this, but I think this volume affirms the need for interdisciplinarity. And fourth, similarly, I find the critical assessment of scholarship and the scholar to be encouraging, and permit me to add this, also therapeutic. So in his chapter, Hoffman poses a difficult question for us. Who is the other in comparative constitutional law? To me, this is one of the most useful questions that we must confront if we are to engage in a critical conversation about the field. And may I add, it may also lead us to some uncomfortable answers. Now, Oklepich, in his chapter, critiques the act of comparison. His analysis exposes the politics of comparison, echoing the work of Gunther Frankberg, which again, I found to be very useful. Now, Oklepich asks at page 105, whose voices are the partisans of Southern perspectives amplifying, modulating, and translating really? I take his question to be a question about the South of the Souths. A Southern turn, if not done in a thoughtful way, can yield superficial results and have its own marginalizing effect. One way to avoid that, perhaps, is to think of the Southern turn and the double turn as a cyclical movement that would also be conscious of the need to decenter itself. So reading and reflecting on these 3 chapters together has been a remarkably helpful, but also troubling intellectual engagement for me. And here I say this as a compliment. So moving further, I see a tension between chapters 2 and 3 with the introduction. Chapter 1, or the introduction, is a call to the double turn, the southern turn and the double turn. But chapters 2 and 3, to my mind, highlight the difficulties in doing that and questions that project. And I think that's useful and necessary. So read together, these 3 chapters, while offering a certain bold move, is also cautious and highlights the need for critical self-reflection about the epistemological challenges that await us in trying to understand what it means to take the global south seriously in comparative constitutional law. Now, this brings me to what I see as another healthy tension between the first 5 chapters and the rest. Encourages and calls for a turn to the global south and a double turn. But I read the rest of the chapters as highlighting the difficulties in doing that in a limited theoretical project. Without taking away anything from the value of those independent chapters, I find that it is cashing in on the theoretical promise of the first 5 chapters of the book is a project that remains to be done. Let me just put it that way. So there is, I think, more work to be done in fully understanding what it does mean to develop scholarship from the South, while the concerns in the case study chapters, as I call them to myself, are useful and significant. I'm not sure whether they demonstrate the theoretical promise of the first few chapters. So that brings me to my 4th point. And the 4th point is about, and it's a separate point, is about the symbolic value of this volume. I think this book places us, and by us I mean scholars in comparative constitutional law, in conversation with debates that are going on in neighboring disciplines and beyond. So whether it's history, anthropology, or even marine biology. I think we are going through another moment of decolonization. Of course, it has similarities, but also differences. And I'll only make this point on that. If the 1960s was a moment of decolonization of the political, in the sense of the rise of independent states, I wonder whether we are currently in a moment where we are decolonizing or talking about decolonizing a field that was central to the project of the 1960s. So in other words, comparative constitutional law, to the extent that there was such a field in the independence moments of the greater part of the world, was very much a Eurocentric body of knowledge. But in 2020, I wonder whether comparative constitutional law is sort of being open and receptive to the idea of decolonization. I mean, the 1990s is perhaps a different moment in comparative constitutional law. So in a increasingly, so to borrow a popular phrase, multipolar world, perhaps the field is now open and receptive. It has definitely borrowed and echoed from law and other fields of law, such as law and development, TWAIL, and the critical legal studies movement. But here again, I just want to add a word of caution that these intellectual engagements must not lose sight of the important analytic and descriptive work that we do. And I think the critical engagement can only come alongside of the analytical and descriptive work we do, because that will provide the foil against which we can think about what it means to decolonize comparative constitutional law. And finally, about the future, the impact on agenda setting in the future. Again, this volume makes it easy. One can point to the volume and talk about the importance of going back to the drawing board in at least 4 areas. One is on epistemological reflexivity. How do we begin to unpack the assumptions, dominant assumptions in our field? the same with the methods that we approach. And the third is, of course, collaboration between scholars and institutions. And I can tell you, having returned this year from a different place of work and having been supported by my colleagues and institutions in my work currently in Sri Lanka, I cannot emphasize the need for thinking through collaboration. I think it's extremely important. And finally, I think this is also an invitation to go back to the drawing board in thinking about the relationships between the scholar, practitioner, and activist, to the extent that these are discrete roles that we see in the field. So that's all I want to say for now. And let me just end by congratulating the authors and thanking them for creating this intellectual space for such a useful conversation. Thank you.
Okay, great. So I think we'll now just, we'll take questions at the end. So we'll move on to Macha to take things to the next commentary.
Yeah, so thank you so much both for introducing me and for having me here. It's a real pleasure to be part of this conversation with so many very esteemed and knowledgeable colleagues, and for, in a way, having the chance to read the book. And as I was doing so, I thought back to an article that was written in 2011 by Teemu Roskola, and it's called "Where is Asia and When is Asia?" It's one of the favorite articles that I like to prescribe to my students when they take my class on comparative legal systems. And for those of you who haven't read the article, Roskola says, well, the answers typically given are, where is Asia? Well, it's not in Europe. When is Asia? Well, it's not now. And he criticizes this, but it's in a way, it's a bit of a pessimistic kind of article. And in it is a plea to change that perspective. And I was therefore reminded of it when I read the book, because what I think that Philip and Michael and Maxime do is they offer a very persuasive and rich inquiry into the related but wider concept of the global South. And the answer now is very confidently that the global South is all around us, and it's relevant across time. It's relevant in the present, it was relevant in the past, and it will be even more relevant in the future. So that also brings me to the notion, if you want, of the global South. And Jed has asked me whether I would want to share some thoughts on how I approach that notion or what I think about it. And as I was writing down my thoughts, I thought, let me do that from the discipline of comparative law generally. And let's try and do that from somewhat of a practical perspective, because the book also, and I think that came out very nicely in the introduction, aims to discuss the implications of a Southern turn for comparatists. So what I'd like to do in this very short intervention is hopefully address 3 points. The first one is a bit longer and the other one are shorter. So the first is whether we ought to have a single concept to achieve multiple and varied changes in the usual approach that we take to comparative constitutional law. And then secondly, how insights from the general comparative law discourse, and notably our familiarity with legal families and taxonomies, may assist our thinking about what is distinctive in the Southern experience. And then finally here, I hope building on the points that Dinesha just made, really excellently, is to engage with that question, who ought to tell the stories of the global South? And what are the ethical responsibilities of those in the global North in that regard? Okay, so let me start with my first point about one concept serving multiple purposes. Now, as I read the volume, at its core, it calls on us to decenter the West or the Northern constitutional experiences that have so far been the principal ingredients in creating both the language and the frames that we use when we conduct comparative constitutional law. Now, I am from the global North, that's where I've been trained, but for close to a decade now, I've been based in the global South, in Singapore. And you could here already say, well, to what extent is that a classic representative of the global South or not? So I'll come back to that a bit later on. Now, but having, in a way, grown up academically in Europe, I've seen a number of the assumptions and biases that this book is agitating against at play. A blatant disinterest in what happens over there, to the benevolent, yes, we care because we will show them the way to enlightenment and democracy and everything else that we have that's good and they don't yet have. Now, at the same time, over the past, almost 10 years, I think I've been very privileged to see in Singapore, as well as through visits in other countries, what truly happens in part of the global South and how constitutions and constitutionalism are perceived by those actually living it. So I say that, if only to say that from a personal perspective, I wholeheartedly agree with the core claim that we need to adjust perspectives, and we need to adjust many of our perspectives and approaches. Now, what the book does, it offers us the concept of the global South as, in a way, that change maker concept. And the editors also acknowledge, and they do that in chapter 1, that there is an internal plurality that is inherent in their proposed understanding of the concept of the global South. And I think that also comes out very clearly in the way that the different contributors have conceptualized and used the global South in their chapters. Having said that, I'm still not entirely convinced whether it's helpful and whether it's desirable to invest a single concept with spatial, ideological, and methodological content. So let me elaborate on the reasons for my hesitancy. So first, the argument to move beyond what Ren Herschel has called the usual suspects, so a spatial shift in perspective, I would say that appears poised to be generally accepted. It's increasingly the case that when one offers the selection of countries that you want to compare with, there's the question, do you do something with the global South? And if not, say something about this, justify it. Now, what I think is more, the claim that the comparative law discourse ought to cover the vast majority, if not all, constitutional systems is not a very controversial or contested one. And I think that's because it has a neutral character. The aim here is not to pursue a particular political or ideological agenda. It is to pluralize knowledge, as the introduction points out. And that, of course, is entirely in line with the quintessential promise and appeal of doing scholarly comparative law. We cannot argue with that. Having said that, I would suggest that this lack of controversy about geographical expansion is crucial, because a spatial shift in perspective seems to me an essential prerequisite for rethinking the epistemological assumptions. And that's precisely because the distinctive constitutional experiences that we would leverage to effect that epistemological change seem particularly prominent in what is the geographic global South. However, when it comes to the selection of the different themes about what is distinctive, and even more so if we want to use global South frames to rethink the discipline and its framing in its totality, so the orthodoxies, the hierarchies, I think there will be less equanimity among scholars. And the fear I would then have is that if we use the global South as a catch-all concept, it might hinder our effort to get that general paradigm shift, because there could be resistance against part of the global South that might jeopardize the general acceptance of the global South. Okay, my second reason is this. More pragmatically, there could be a risk of confusion as to which dimension or dimensions of the global South one needs to address when we conduct comparative constitutional legal research. And I think that might be especially true for those that are ensconced in the global North approaches and the global North ways of thinking. And that includes the new entrants to the field. So if I would have a graduate student who says, I want to do global South research, what is this person expected to do? Should this person look at constitutional systems in, say, Asia, Africa, Latin America? Should the person focus on a theme that is associated with the global South, even when it is explored in a global North jurisdiction? Or should the person perhaps deal with, say, a normative approach to citizenship that is grounded in a lived sense of belonging rather than based on a Weberian understanding of the state? Now, I suspect the answer we may want to give is, well, any and all of these above. But that means that the Global South body of research might have very fluid boundaries, and it might be internally quite disparate. What does that mean? We could get several parallel discourses about the concept of the Global South and the implications for comparative constitutional law. These may coexist, but not speak to one another. And this might then mean that rather than these conversations being at the heart of a 21st conversation of what our discipline is about, they remain at the periphery. Okay, my third reason. I think we want to remember that comparative law has very long been bound up with the nation state, both generally as well as a subfield. And that remains the case to the present day. So there is a very strong tendency to think about comparisons in status terms. And that might cast doubt on the sensibility of using something that many will initially, if not primarily, take as a spatial indicator to effect a change in a non-spatial approach. So here, I think the Global South would function as a metaphor. So when we talk about the epistemological or methodological changes. And there is a wonderful quote by Kimley Shepard where she says, metaphors matter in shaping thought, so it's crucial to get the metaphor right. And if we look at what has happened with the third world as a concept and how that has been initially understood and reinterpreted and perhaps misinterpreted, is there perhaps a risk that the Global South could have that same fate? Okay, my final point about using the Global South as a catch-all concept is this. When we think about the epistemological and the methodological dimensions, I wonder about the choice to align with the scholarly developments in international law, and in particular the TWAIL approaches, because they embody a certain political and an ideological agenda. But if I read the book, I hope correctly, then the epistemological and the methodological shift that is advocated would not just be limited to the geographic Global South. It's supposed to infect the entire discipline. And as such, I wonder whether it could be equally or even more profitable to draw on comparative law as the general field, of which comparative constitutional law is the subfield. And that would mean that we would draw on some of the debates and the approaches and the concepts that have been developed in that field. So let me mention the term legal pluralism, which also makes an appearance in the book. If we read William Twining or Brian Tamanaha about pluralism, they would say that is as prevalent in the North or the West as it is in the South. And I think that resonates very strongly with the point that was made that there are Global Souths in the Global North. I was also reminded of the concept of legal culture, which says we need to have a socio-legal understanding of what law is, rather than a formal understanding. We should focus on legal consciousness, legal mobilization. And that, I thought, would tie in very nicely with the questions about access to justice and the relationship that might exist with the law or against the law. Now, methodologically, the concern with interdisciplinarity has found favor in at least a large subpart of the general field of comparative law, where there is talk about deep-level comparative law, about socio-legal approaches. So here I think of, say, the work of Catherine Valker, or Nora Demleiter, or Mark van Hoeken. So in sum, while broadening the geographical coverage of comparative constitutional law and rethinking epistemological and methodological and institutional approaches, I think they're all worthwhile aims in their own right. I'm not quite sure that we need or should have the Global South as a single catch-all concept that will help us recalibrate the discipline across all of these dimensions. And I would be somewhat more comfortable to have different concepts for what I think are qualitatively different aims. Okay, let me briefly say something about my second point, which takes the Global South as an exclusively, if not primarily, spatial concept. Now, I think that spatial understanding is actually quite prominently present in the book. In the first chapter, we read about the importance of capturing experiences in a particular place. The examples in that chapter, as well as in the second half of the book, are all situated in countries that are located in the Southern Hemisphere. So when I was reading these parts of the book, I was reminded of the legal families approach and efforts at classifying or grouping jurisdictions together based on a shared set of features or legal history. Now, this is a very common approach in comparative law generally. And what often happens is that geographic association is a very popular organizing principle. Now, again, I think we can draw usefully on the debates about legal families and classifications in thinking through what might be distinctive in the Global South. So, a few points that we ought to think about. One, what is the degree of internal homogeneity within each category or within each family? And what features justify grouping countries together? Now, we heard about the shared legal history, the colonial context, and I think that that indeed is a very pervasive feature that would tie the countries together, geographically speaking. I'm a bit less certain when it comes to the themes, whether they are truly shared. So, for instance, if we think about constitutions as vehicles for socioeconomic transformation, I can think of examples, and South Africa is I suppose the classic one to mention. But Junrong Ray and Chang Wen-chan have, for instance, argued that when we look at Japan and South Korea and Taiwan, we actually see a lot of textual and institutional continuity during constitution making. And if we look at the Pacific and the Pacific Island states, we see a similar pattern. There's actually a lot of continuity rather than transformation. And then, and that's a point that also came up earlier, I think there might be themes that would help us tie together some parts of the geographic Global South, but that are probably not shared enough across the entire hemisphere. So if I look to Asia, examples that would come to mind are the role of religion in the state and in society, the presence of forces or institutions beyond the classic three branches of government, so the military, for instance, or the monarchy. The fact that there tend to be very thick cultural matrices of what is a good society or when one is a good citizen. Now, the second is the point about if we have a family, who is the family representative? Because we might not be able to cover all the countries. Now, typically when we talk about legal families, civil law, then it's France and Germany, common law, then we look towards the UK and the US. And what I wonder about is if we use the Global South as a family, are we seeing the emergence of favored representatives? Brazil, South Africa, India. Where's the Pacific? Where's the Middle East? Where is, and this is a favorite example, where's Bhutan? Bhutan is fascinating, but it doesn't seem to be in our usual suspects in the Global South. Okay, the third point here. How distinctive is the Global South as, if you want a family or a category, vis-a-vis the Global North? Now, again, and this came out very nicely in the introduction, this is a question of degree. It's not as if the two are like polar opposites. What I think we can learn here from general comparative law is that the move is very much towards embracing hybridity because of a concern that there is an overemphasis on difference. That the moment we say there is the Global South, the Global North becomes the other. And even when we say we shouldn't find distinctions and it's a question of degree, we might engage in othering. And I think perhaps the Global South might be viewed more as a temporary placeholder that would nudge us to expand our comparative constitutional law knowledge database and enable the creation of a more accurate map of the constitutional world. And that could mean that the usefulness of the Global South as a general concept will progressively diminish once that knowledge base grows And we will find shared themes that allow smaller types of, if you want, groupings or family members. Okay, I'll very briefly, if I have the time, Jed, do I have the time? 2 minutes. That's perfect. How to do Global South. Who gets to tell the stories? Now, there's a lot that can be said about this. I think that what we may want to think about now is that as we turn towards greater engagement with the Global South, we may have those who are based in or trained in the Global North telling the stories of the Global South. And on the one hand, we could say that's beneficial because the stories deserve to be told. And it doesn't matter who does it as long as they're out there. But I think on the other hand, we want to be very cautious here because once the narrative is there, how do we correct it? So when stories about the Global South are told by non-Southern voices, and I leave to side the question what a non-Southern voice is, I think there are some ethical responsibilities. And here we may want to take our cue from debates about cultural appropriation in literature studies. So I think one, if the Global North or Northern scholars do this, they should acknowledge that it's a privilege to share about Southern stories. I think that they ought to, and that includes, so I will include myself in this for obvious reasons. I think the question should be asked either internally or explicitly, whether and why someone is best placed to report and assess on a global Southern constitutional system. I think that there's a question of integrity. We need to seek out the views, the input, the feedback from those coming from the jurisdictions that we write about. And I think we should do that not just before publication, but also afterwards. And then finally, as much as we would want to hear about Southern voices speaking about Southern experiences, I think we should also invite Southern voices to give accounts of Northern experiences and how they would read Northern approaches to constitutional law if we really want to transcend any form of us versus them binary. Thank you very much.
Okay, great. Thank you very much. And now we'll move on to Dina.
Right. Thank you very much. Thank you to Jedediah for inviting me, and thank you for giving me this opportunity to engage with this fantastic and fantastically rich book, especially because it sits somewhat orthogonally with my usual expertise, which is in international law, and I'm going to come back to that in a second. So when Jedediah got in touch to ask me to do this, I was initially, I said yes, it was ages ago, it was future Dina's problem. And then as the date came closer and closer, I started panicking about what could I possibly contribute to a debate about comparative constitutional law, being myself an international lawyer. And when I sat down and finally read the book after dragging my feet and procrastinating in any possible way, and impossible ways sometimes I could come up with, I realized there was actually a lot there. And part of the reason there was a lot there for me to think about and to learn from was because the editors themselves and occasionally the contributors were very explicit about building bridges and making links between their intellectual and political experiment and third world approaches to international law. So that kind of pepped me up. The other problem was, as I turned out the last 15 minutes, never prepare your introduction, your comments without knowing what the person before you is going to say, especially if they're going to say basically what you said, but much, much better than you're going to say it. So here is my thoughts. At halfway through the presentation, I panicked. I was like, should I change it? I was like, I don't have enough time to do that. So there is going to be some degree of overlap because perhaps unsurprisingly, what I chose to focus my comments on is what does the Global South and what does the Southern turn do for this book? And I take my cue primarily from the introduction, but also from some of the chapters. And I thought what I found really, really interesting, and I think it has come out in this discussion, both in Michael's comments, but in subsequent observation, is a certain ambivalence about the concept of the global South and the intellectual work that it does. And it seems to me that both in these discussions, in the introduction, and in most of the contributions I had the time to go through, the global South seems to mean three distinct things. And the South in turn seems to mean three distinct things. The first thing is the global South and the South in turn as a quest for completeness and as a quest for pushing back against provincialism and parochialism in the way comparative constitutional law has been conducted so far. So this is almost a common sense, let's say, understanding of the global South, an understanding that says, you know, if you're doing comparative constitutional law and the biggest distinction you can come up with is the distinction between, you know, France and England, so 10 kilometers across the channel, probably the conclusion you're going to come up with are going to be a little bit shaky, right? So, and I'm saying this, at the same time, this is no small feat, right? It might be the feat, it might be the aspect that is less conceptually or politically ambitious, but I think in terms of elementary disciplinary seriousness, saying that you're doing comparative constitutional law or saying that you're doing any sort of knowledge production, if you're having an almost explicitly and shamelessly and proudly unrepresentative sample, and also if you only are willing to hear from people who like 5 different names, quite frankly, first names, then the conclusion you're going to reach are shaky. So I actually think, and I'm going to echo Dinesha here, about the extremely valuable material this edited volume provides to those who at the very least want to adopt this common sense understanding of the South and I think both the more theoretical chapters, but also the chapters that focus on particular constitutions and do this comparative exercise will be extremely important. And I think they will be, and that's the highest compliment I have for the book, it will be extremely useful teaching material. I don't have anything better to say for the book than I would love my students to read this. So this is the first idea of the South and 10. The flip side, or the darker side of the common sense understanding of the South and 10 is that this is a renewal exercise or even a reauthorizing exercise, right? We are keeping our old ways, we're keeping our old concepts, we're keeping our old methods, and we are adding new material. So it's in a sense a way of renewing a discipline that perhaps feels like it's running out of steam without actually challenging any of its basic understandings. And I don't think that this is what this book does, but I definitely think it is open to that reading. The second idea of the South or the South and 10 in this book that I could detect perhaps a bit louder than the first was the idea of the South and 10 as a sensibility, and that was actually said explicitly in the introduction, and especially as a sensibility towards the epistemic injustice and epistemic marginalization that has arisen as the intellectual corollary of Western imperialism and Western colonialism the last 200 years. So the idea there is that certain not just voices as in identity of the person who enunciates, but certain ways of thinking about comparative constitutional law have been privileged. And I think the unspoken bit is that they have been privileged not necessarily for intellectually solid reasons, right? And the idea, for example, I was really interested in Hoffman's contribution, where he talks about this lay Weberian understanding, perhaps not very, it doesn't necessarily reflect Weber himself, but this lay Weberian understanding that has been so central for comparative constitutional law, with all its intellectual concomitants of the nation state, of rationalization, professionalization, bureaucracy, and so on and so forth. And this is, again, a very important contribution. And I think this is a very important contribution that opens doors as much as it has already exploded. And I'm going to explain what I mean by that. So, for example, one of the points my fellow panelists have already raised is who can talk authoritatively about the South? A way of rephrasing perhaps this question could be, again, not just the question of identity, of, even though I do agree about what's important, but also what sort of methodologies are considered authoritative and acceptable when it comes to talking both about the global South, but also talking about constitutionalism in general. And what I'm thinking, for example, here is that if we adopt this understanding of, let's say, epistemic injustice, I think space is made, if not necessarily yet explored, about more popular engagements with constitutionalism. So I'm thinking in the South, but also in the North. So I'm thinking of like Rohi De's recent book, A People's Constitution, right? In which the South does not just exist because he's talking about India, but because he chooses to have a very robust social legal understanding and everyday understanding of what the Indian constitution is. Like, the question is, how does the Indian constitution look like if we look at it from the perspective of street vendors in India and of sex workers in India and of butchers in India, all of whom decided for different reasons to bring cases in the constitutional vernacular in order to argue for perhaps unpopular cases within the Indian nation state. So that, to me, when it comes to the question of sensibility, one of the things sensibility ought, if I was to be prescriptive, to include, if it is to be something more than liberal pluralism or liberal acceptance of, for almost a folkloristic understanding of pluralism, would be something that turns into methodologies that perhaps have been part of, let's say, heterodox law and development. So in feminist law and development, this sort of social legal work is bread and butter, but I'm getting the sense that in public law and also in public international law, because these are considered, you know, serious, robust subjects that happen in Geneva or happen perhaps in the Constitutional Court in Delhi or in Bogota, they're not allowed through the door so much yet. And the third register in which the global South or the South intent appears is as a metaphor or as a placeholder for categories that I think are not, and I agree with Margie here, are not appropriately captured by a geographical metaphor. And my sense is that there's at least three categories there. There is class. When people say there is South within the North, they tend to talk about class, they tend to talk about race, and they tend to talk about indigeneity. Also about other things, perhaps gender could come into this conversation. But I think the metaphor that says there is South within the North usually tries to capture the particular forms of oppression and exclusion from the corridors of power that comes from the intersection of these three, I will not call them identities, I will call them relations. And in that sense, for example, I was quite jumpy when I read in the introduction Australia being referred to as a former settler colony. My question is, if that's a former settling colony, then what I am doing here, because I think I am very much a settler. But also the fact, it's not just a terminological disagreement. For example, in Australia, by far the most interesting constitutional debates of the last 20 years and the most politically fraught constitutional debate of the last 20 years has, of course, been the question of constitutional recognition of Australia's First Nations peoples, right? And there one can see, if we want to talk about global North and global South, one can see, let's say, orthodox and heterodox understandings of what this constitutional recognition should look like, clashing in public, both in scholarship, but also, and I think that's much more important, in public life. What I want to say by that, and what I want to say by the point that I think a geographical moniker is not a good way of expressing these relationships of class, race, and indigeneity, is not unique to the book. And I want to make this extremely clear. I think the editors did a tremendous job, and the contributors who tackled the question did a tremendous job in tackling an extremely slippery question. And I do think, by the way, that Tueo very much suffers from the same theoretical aporias, or it doesn't suffer, maybe it thrives in the same theoretical and political aporias. And my sense is that if our concepts feel so slippery and sticky at the same time, this might not exactly be our intellectual fault. I think all three editors have really, in both in this and in other cases, shown their intellectual proneness, right? So I'm not saying that anyone is being intellectually lazy or inadequate. I think what is happening here, and Jedediah kind of touched on it, is that Tueo, for example, came into the disciplinary or academic scene right at the moment, or right after the moment in which the political coalition behind, for example, the idea of the third world had actually disintegrated. So we are in a very particular situation in which third worldism, understood, of course, not as a place, but as a project in Vijay Prasad's moment, had actually collapsed. It had collapsed both for endogenous reasons, one of which was the fact that the political solidarity between decolonized states started disintegrating between oil-producing states and non-oil producing states, and the fact that 1973 impacted them extremely differently. It began disintegrating because it came under sustained attack from the former colonial powers, and it began disintegrating also because powers within the global South, or within the third world, that had been pushing this radical anti-colonial agenda, were actually defeated. And they were sometimes defeated through normal electoral politics, but more often than not, they were defeated through a series of extremely violent, either coups or prolonged processes of counterinsurgency and violence. So what I'm trying to say here is that I feel people who do this work right now, let's say I'm thinking about Tueo, but I suspect suspect this applies to comparative constitutional law. We have a marked problem of constituency, which is who are we talking to outside of academia? Because it seems to me that the political alliance, it seems to me that like, to be very blunt, people who were doing left-wing academic work in the 70s, even if they were the wackiest in their approach, they had a constituency. That constituency perhaps was never majoritarian, it was never a huge constituency, but there was a constituency. Feminist legal scholars in the 70s, for example, had a very clear and identifiable constituency, both within their nation states and beyond. The relationship was not always very smooth. The relationship was not always very straightforward. Theory did not always translate into political mobilization in a straightforward way, but the relationship was here. And I don't, in a sense, I don't have a solution to this, obviously, because what I'm trying to say is that this is not an academic problem. I do have perhaps not a solution, but I have a way to start thinking about it, which is a sense that perhaps discussions of epistemic injustice and epistemic marginalization, and even discussions about the mere like smugness and narrow-mindedness of the mainstream, both in international law, but perhaps also in comparative constitutional law, have come to almost wholesale replace discussions about material injustice, right? That we talk so much about epistemic injustice and epistemic marginalization because the debate that we could have about material injustice, we don't always have the links to those at the, at the sharp end of this material injustice to have these discussions in a meaningful and perhaps productive way. So what I'm trying to say with all this is, I think the contributors, and I think all of us who work in these areas and using these concepts, we are doing truly our very best, but we are doing truly our very best in a very politically impossible situation. And I think perhaps acknowledging that and starting to think through what to do with this disjointed status might be a good place to take the conversation from now on. Thank you very much.
Great, thank you very much. And now for our final contributor, Rehan, take us home.
Thank you very much, Jed, for the introduction. Thank you to CCPL, PoGen, Winnie, Alex for organizing this. I asked to go last and now I regret it after those really, I think, terrific and insightful comments from my fellow discussants. I want to echo much of what's been said by saying I think this book is really terrific. I really enjoyed reading it, and I think it really represents a major advance in our thinking about the Global South. I particularly like the push for greater methodological and institutional diversification and the call for epistemic equality between the global North and South. I also want to echo Dinesha in saying that I really found this book productive and useful for examining my own scholarship more critically. I think it really does open up an intellectual space to discuss some of the hierarchies and inequalities in the field. More generally, I think this book, and sort of perhaps a few others like the Maldonado volume a few years ago, which the introduction references, really do suggest that the Southern turn is upon us in comparative constitutional law. And this is a very good thing, right? As chapter 1 and Jed's chapter notes, right? This should reinvigorate the field and result in richer scholarship, both in the global North and global South. And so while I think this turn is both welcome and long overdue, what I want to sort of focus on today is, I think, what might be the next step. So now that we've acknowledged that the turn has happened and we're taking the global South seriously, which is excellent, I think our excitement to engage with the global South should not lead us to overlook some of the problematic power dynamics within the global South itself, right? And I think for the global South to be an equal partner in the comparative constitutional enterprise, right, for there to be epistemic equality, I think internal hierarchies and pathologies within the global South require the kind of critical attention that we often try to give to the global North. So in my remarks today, I'd like to discuss two dynamics that I've observed within the global South that I think need to be subjected to more careful attention, unpacking, and critique. The first dynamic echoes very much one of the points that Marcia made, which is that I think regional hegemons have come to dominate comparative constitutional scholarship involving the global South. So examples would include India in South Asia, South Africa in Africa. There are potentially others like Brazil in South America, but I think India and South Africa are the paradigmatic cases. And these regional hegemons are often presumed to represent, and in many instances do actually influence, not just the constitutional doctrine, but really the constitutional imagination of their regions, while less powerful countries in those regions and the developments therein are largely neglected. Right? So this volume, it's not just this volume, my own work is very much part of this, I think reinforces hierarchy, right? So India is the case study from South Asia. South Africa is the subject of two chapters, one of which discusses the potential for South Africa to serve as a model for African constitutionalism generally. And so how did we get here, right? So how did we get here? How do we get to the stage where, these sort of exemplars of particular regions sort of often stand in as the representative of those regions? And I think there are a couple of factors at play. So one is the centrifugal force exerted by these countries or jurisdictions themselves, right? And we can see this both in the migration of doctrines and in the movements of people, right? So I'll just focus on South Asia, which is the region I know best. So doctrines like the basic structure doctrine or public interest litigation, these are things that initially developed in India and then traveled in various degrees and various forms to Bangladesh, Nepal, Sri Lanka, Pakistan, etc. And then particularly with respect to smaller countries like Nepal and Bhutan, which Marcia mentioned, most of their lawyers and judges are then trained in India, right? And so they bring back home a sort of Indianized sensibility about what law looks like, what transformative constitutionalism is, etc. But there's a second dynamic at play, which is the kind of outsized attention that these regional hegemons get in comparative constitutional studies, particularly those published in the global North. And I think there are a few things at work here. So one factor is that leading domestic constitutional scholars in the global North are often only familiar with or exposed to a few hegemonic cases. I'll give the example of Frank Michelman, who I admire very much, who's a teacher of mine, well-known American constitutional scholar, not by any means a comparativist, but he was involved in South Africa in the mid-1990s and was very interested in South African constitutionalism. And that was the one kind of international case or comparative case that he would discuss, and often in very glowing terms. And I don't think Michelman is alone in this respect. I think a lot of American constitutional scholars, to the degree that they know of for sort of global South cases, South Africa is probably the one they know best, probably followed by maybe Brazil or India. Another factor that I think is important here is that leading scholars and judges from these regional hegemons are more likely than other representatives from the global South to be invited to speak or hold visiting positions at leading universities in the global North. So I think the quintessential example of this is the Yale Law School Global Constitutional Seminar, which is a seminar that was held for many years, bringing kind of leading judges from across the world to Yale. It was people like Justice Bhagwati, who I've written about, Justice Aaron Barak in Israel, et cetera, exactly the kinds of judges you would think from these kind of exemplar countries that were invited to participate, to kind of share tactics and to build, right, which now I think has been shown to be a failed project, but to build a global community of judges where, pursued global constitutionalism together. And I want to suggest that this outsized attention paid to these regionally hegemonic cases feeds back to the global South and leads to certain topics becoming trendy, even though they may not be that relevant to circumstances on the ground. And I think the best example of this is public interest litigation, right? So people like Justice Bhagwati, who I mentioned, he was a Supreme Court justice in India in the 1980s, basically went on a world tour promoting his own judgments on public interest litigation. He gave talks at Columbia Law School. He went to sort of various judicial forums. He befriended Michael Kirby in Australia, who then kind of spread the gospel there. And because of people like Bhagwati, public interest litigation became to be seen as the contribution that India, and hence South Asia, made to the study of constitutional law, right? And then this feeds back into South Asia, and sort of even in other countries of South Asia, public interest litigation then becomes a major topic of discussion. And this is despite the fact that, for instance, less than 1% of the Indian Supreme Court's cases actually deal with public interest litigation, right? But it's because it was something that was picked up on by folks in North America in particular, and was spread by people like Justice Bhagwati, that it kind of gets this outsized attention. Meanwhile, sort of developments on civil and political rights, including voting rights, post-conflict and transitional justice in Nepal and Sri Lanka and outer parts of India, are rarely found in the pages of at least American and British law journals. So I want to caution against kind of the Southern turn reifying different hierarchies, right? So where instead of norms and doctrines flowing unidirectionally, as the editors put it, from the global North to the South, we have instead a unidirectional flow from the regional hegemon to smaller jurisdictions in their orbit. And the second dynamic, and this is a very sociological kind of observation, but I'll just make it anyway, is just the lack of interest I've observed in South-South comparative work, especially among younger scholars. So now this is partly due to strategic considerations, right? So if you want to publish in a leading journal in the global North, it makes sense to choose a topic and or case studies that are familiar to the publishers and the journal editors. But I think the problem is deeper than that. So, having taught now for a decade, first in India and for the last 4 years in Hong Kong, I'm yet to have an undergraduate or a JD student approach me with a proposal for a South-South comparative research paper. It's always something like, how does India's abortion regime compare to Roe v. Wade? Or how does proportionality in Hong Kong courts compare to that in the Canadian or British courts? And I found this tendency very difficult to fight against because students, in my experience, do not merely sort of lack the knowledge of what happens in other parts of the global South, even in neighboring jurisdictions, but often don't seem interested in those developments. And then I think this is again replicated among junior comparative constitutional scholars and perhaps all comparative constitutional scholars. So I'll just end by saying I hope this excellent book and the conversations around it will begin the process of reversing some of these tendencies, right? And help develop a sensibility in which comparative constitutional scholarship on developments in the global South are valued in their own right, and not merely because they're juxtaposed with developments in the global North or celebrated by sort of famous professors or judges in North America and Western Europe. So I'll end there. Thank you.
Great. Oh, you mentioned one of these pivotal experiences in my own trajectory, going to exactly that conference that you mentioned in law school several times as part of my own anthropological education and how these networks operate. And maybe I'll have time for some comments in that genre later. But as an organizer, I can't complain with both brilliant and on-time contributions. It's like a fantasy combination. And so that does leave us time for conversation. So I'll leave it to Michael and Philip now to give their responses to these, an impossible task to respond to all of these brilliant.
I don't know, Philip, do you want to say, since I already spoke?
Yeah, I mean, it's really kind of overwhelming. I just wanted to really thank you from the bottom of my heart. It's just incredibly rich and fascinating what sort of insights and observations and arguments you've made about the book. It's like eating not just one, but at least 2 or 3 huge cream tarts. And so I think I have to digest a lot of that. And I would actually ask you to perhaps, if you have written notes, send them to us, because I would really love to think about them in more depth and longer. perhaps just 3 points. I mean, it's a little random, but just 3 points I wanted to make. First of all, I wanted to acknowledge what came up in Jed's first comment, and also in Dina's, and what Dina called the problem of constituency, and the difficulty of using perhaps the global south in that it enables a binary that is then used in political debates that we don't want to actually encourage. And I very much see this point. I very much see the risk and the danger of the notion of the global south, and a number of arguments sort of connected to that being used in autocratic and other constellations. So I very much see that. At the same time, and that leads to the larger point which many of you made about the notion of the global south. I just wonder. I mean, we do share the ambivalence that many of you have expressed in the notion. I mean, that's the basic kind of sort of sentiment, perhaps, that we also had when we started to think about this, when we started to try to use it. So there is for sure a very big ambivalence, and which we try to address by making very clear that the South is not conceivable without the North, and that it's very much the entanglement between the two that seems to us is sort of particular and distinct of the experience. So in that sense, I think it's in a sense the South is only sort of part of a dialectic. So only when you think the South, you have to think the North, and then you come to the whole. So to some extent, it's a dialectic kind of approach that tries to think these two categories together, not as a binary, but as something that we can somehow sort of reflect in this kind of a dialectic way and sort of mutually reconstituting kind of way. But there is the ambivalence, and I see that. And so perhaps, I don't know who said it, Mark, I think the idea that perhaps it's just a temporary placeholder. So perhaps it is really a notion, a concept that we use now, fully aware of the risk and the slipperiness that's in it. Just to visualize a field and to visualize sort of a universe of experiences and jurisdictions that we want to bring into the conversation. So perhaps that's the way out. And then one final remark is this kind of what follows from this is basically indeed a call to collaboration. So we definitely share, and that's why we brought it up already in the introduction. We hope prominently enough the ethics of doing comparative law in this context, and the ethic responsibilities that come along with it. So who's to speak, and how do we speak, and how do we organize it? So I'm very much aware of that. But I think what a role of us in the global north should be is surely one of a listener, but also, as we perhaps sort of badly call it, the enabler. So in the sense of using certain resources that we have just to make discussions and projects and PhDs and workshops possible. And so that is something that I feel very strongly about, that indeed this book is perhaps just more an opening to a conversation and to a larger research that should unfold in the coming years. And I would be extremely happy and grateful if also among these the people here on the screen right now, and of course many others, we can work on that. So it's indeed the journal World Comparative Law is one forum, but hopefully also others where sort of those types of projects can be somehow pushed. And if this book is somewhat like a little kind of motor and engine on that, then we will be very helpful. Thank you.
Maybe I can just briefly add to say that I was really happy. In particular, we've done a couple of launches now, And this one, I think, was the one where most people really engaged with this notion of the global South in a way that was very productive for me, and where I thought that gives me a lot of food for thought and reinforces, I think, two things. First, the idea that we use the notion pragmatically, right? So I think we're not doctrinal about it. It's a means to an end, and the end is to pluralize the discipline and to emancipate voices that suffer from multiple exclusions, north-south, but also internally. And if there are sort of other ways of achieving that, or the global South makes a contribution to that end, but it's certainly not the only way of doing it. It's a door opener, I think, that is good at breaking with unitary frameworks. So 2 categories are better than 1, I think, but it's of course not enough. It's good to unite heterodox approaches to produce a form of sort of solidarity. I think that's what Daniel Bonilla had in mind at the time. That's how I read him when he came up with this idea. So it's a form of self-identification for scholars that have been excluded and that then think together. But we should also be pragmatic with the risks. And if there are risks, like Jed and Marty point out, of sort of fragmentation, of misunderstandings, of appropriation, then we need to be sort of communicate this in a way that is appropriate, and maybe use other terms in different contexts. So I think context sensibility is important. And the second point, I just wanted to point out how sort of what the next steps are that we've already taken. I mean, this volume has been in the making for a long time, and of course, things have moved on. And I think that the project we're currently doing, and that Jed is already sort of part of, has the title of Varieties of Constitutionalism, which is a term that we haven't invented, but that I think captures nicely the move from a binary to a sort of more complex taxonomy, where we look at sort of liberal, transformative, authoritarian, post-colonial, what adjectival constitutionalism to say, what sort of not legal families maybe, but sort of this notice of varieties. I think I see this as a next intellectual step. And then, of course, the next step, and that for me, this will be the one coming after this project, is what another project in Geneva is calling reversing the gaze. That is to have Southern scholars look at Northern experiences from their perspective and see what comes out of that. And I think for that, the Global South is useful and doesn't necessarily carry sort of some of the risks that are pointed out in Southern. So for me, as a Northern scholar, that is also sort of an avenue for future research. And we'd be happy to soon, hopefully, be able to have some funding to have scholars come here and then teach us what they see when they look at what we're not seeing.
Okay, so if anyone in the queue wants to ask questions via the Q&A function in the Zoom, go ahead to free to do that, and I can forward those to the panelists. I think I'll just for a moment take again the chair's sort of privilege and say, and part of this, I think I set this to some of the contributors about talking about the Global South because of my own sort of strong anti-formalist tendencies, right? And I know it's still possible to be friends with German legal scholars and be a deep conceptual anti-formalist. Michael even managed to write something with me. And so since there aren't any questions at the moment, I had a couple things I just sort of offer up. I mean, people are free to have their own thoughts, but just some things that came up in this context. One is, and I think, since this is an area of interest for me, but I think looming and behind some of these concerns, right, is that when people talk about these types of conceptual frameworks and things, I said, like, I always, it's in sort of cheap way, but say, but what about China, right? Where does China fit into your role? I actually was talking to a scholar from Europe and who said something and mentioned China as being part of the Global South. And in my mind, I was like, does China think of itself in the sense that you can talk about China as part of the Global South? Opportunistically, right? And many times they invoke that type of that type of language. But if you're really talking about, things like power dynamics, about, flows in a more material sense, it's very difficult to fit China into these categories. But at the same time, again, being very adroit at playing upon them. If you look just in every sort of daily pronouncement about China's relationship to the world, they're at both times, play the sort of role of historical victim, while at the same time acting out in ways that parallel or at least invite analysis in comparison to past trends. The second thing that sort of come up and then speaking from my experience as an American, right? And especially when Dina was talking about common sense, right? It's commonsensical that you have to do these sorts of things. And I think part of my concern in the writing of the chapter here is, instead of actually having correctives, what you start to see in places that we would call the North is like an opt-out, right? So comparative constitutionalism was very hot when I was in law school, when a constitutional scholar in the United States could talk about constitutional reform in other places. Once they're no longer have that privileged space to speak about what goes on in other places, they don't reformulate, they just opt out. They're like, well, okay, that was a thing that we used to do, but we no longer do that because I'm not really willing to do the type of, looking at other places as something that I would learn from, right? I just shouldn't do that thing, right? So that's one of my big concerns, is this sort of like opt out in reaction to critique, which I think is a very traditional sort of American, if not otherwise, reaction. And then the third thing that is this idea of constituency that was brought up. I mean, is it possible in this context, or is this even an appropriate framework to think about constituency formation and solidarity, right? So I obviously have very strong opinions about what would be required for the grounds of solidarity, right, in a resistance, and they're very material in orientation, right? And I realize, and being in Hong Kong, this is one of the people don't share that, right? People have a very different view of ideas of sort of socialism, capitalism, and resistance, right? In Hong Kong, they're almost inverted from my sort of my priors in that context for very historical reasons. So is this something in comparative constitutional scholarship? Should we really be thinking about generating the grounds of constituency here, or is that really just something that is beyond like the possibility? We may be fearful, right, of some things that may be, again, opportunistically reappropriated, but maybe at best, right, there is an academic intellectual project that itself doesn't lend itself towards that type of constituency formation. So those are just some initial thoughts that I had. People are free to react as they want. So I see Marta, go ahead. There's no.
So I would want to respond to your point about the risk of, in a way, the gates closing and the North saying, well, we've had our dazzle with comparative constitutional law and now we're done with it. And I wonder here what the role is of universities when it comes to the type of international collaboration that was mentioned by Michael and by Philip, which, let me just say, I wholeheartedly support. So what I will say here, and I'll give an example, two examples, one from the Netherlands, one from the UK. So in the Netherlands, in Tilburg, they now offer what is called a global LLB, where you're not trained in the law of a single jurisdiction, but you're trained in the law across jurisdictions in a thematic fashion. So when you are taught constitutional law, what they've done is they've created lists of countries. So there's, a list of, this is basically list A, list B, list C, list D. And the countries on each of these lists share certain characteristics. But what is interesting is that countries like, for instance, Singapore, are explicitly identified as of interest. And these attract students. So perhaps one possible way forward is that if universities remain serious about internationalization, and internationalization not just in their own backyard, but really globalization, then that might create almost the demand for this kind of engagement, because a student will want to come, if a student comes to the Netherlands or anywhere else, only to be told, we'll be talking about Germany and Canada, that becomes dissatisfying. And my sense is that students would become also more vocal in this regard. So I have, if you want, some hope that we see a type of empowerment. And here I also want to add, Philip, you mentioned something about the role of the North as an enabler. And I think I was very struck by this. One of the comments you made at the very last page of the chapter is to say, we also offer translations, and that gives accessibility. And I think we cannot underestimate how incredibly valuable that is and the kind of service that does in creating an inclusive place. So my second very brief example is from England, and it's someone that a number of you will know. Earlier this year, Oxford announced its very first associate professor of Asian laws. So Bri Ngoc Son, who is trained, and I know Rehan, you know him very well. So he's from Vietnam. He studies socialist legal systems, which is not, if you want, your general cup of tea in Southern scholarship. And what the dean said, so I'm just going to quote this here, is to say, Dr. Bri's arrival will enhance the faculty's expertise in several understudied jurisdictions. It will augment our position as a truly global law school. Now, there might be rhetoric involved here, but if we see universities in a way subscribing to this kind of logic, then the hopeful part of me thinks that the global north, whether it wants to or not, will remain part of this conversation, and hopefully with more Southern voices.
Hi, can I pick up the point about constituency building? So I feel that like I don't have an answer for that, especially for comparative constitutional law, right? Because I'm really an interloper here. I do think though, having a degree of analytical clarity and dropping the metaphor when the metaphor stifles thought rather than encourages it is a useful thing, right? So to me, I get really jumpy when people say there is a South within the North. I'm like, are you trying to say there's poor people? Like, because to me, that's what you're trying to say. Just say it, because then we can really try to start figuring out where the fault lines are. And I mean, that doesn't go anywhere clear creating the constituency, but it does at least, I feel, make the debate both more analytically sharp, but also it just even starts the potential of talking about who may or may not be the constituency. So in a sense of like having a certain explicitness about both what sort of unspoken social theory underpins this. That's always something I get quite fixated about, like what do you mean, even like taking the step back, and what is like, what do you mean experience of imperialism or experience of colonialism? Because I suspect when we start having this discussion, opinions will start diverging, and I think that's not a bad thing, right? Because I think also part of what led to the collapse of the coalition behind third worldism was that pretending there was an automatic solidarity where it became very clear that both politically and materially there wasn't, or at least it wasn't as automatic as everyone was pretending it to be. And therefore, when things became a little bit trickier, the coalition collapsed, right? So I think sometimes like just even start thinking what would be the preconditions of constituency building would be an improvement.
Dinesh?
Yeah, so just to respond briefly to this concern, or the potential concern about the global north closing its gates, so to speak. So I read the introduction to this volume as not only inviting a turn to the global south, but saying that the global north has something to read and learn from the global south. So one example perhaps would be the work that has been done in the so-called global south on fourth branch institutions. Studying those developments can be useful for anyone interested in fourth branch institutions in any part of the world, in terms of even institutional design or practice. But in the broader sense, as some others have argued, the global south foreshadows what may happen in the global north. And I have seen some interesting contrast between, for instance, Sri Lanka and Australia, let's say about the role of the military. I'm not saying these are analytically stable ways of thinking, but they just strike me as interesting. And yes, so just those two quick responses. And finally, about constituencies, this is a partial response, but looking if the field is more comfortable with the global south and studying the global south, it's just going to be more helpful for people who work on the global south, because you are able to have south to south conversations with less inhibitions, and perhaps in the long term also have opportunity to publish in places that currently are not interested in publishing anything about the global south. Again, speaking to South Asia's context, there are so many useful conversations. South Asia is again a political construct, but it's still useful to have. But those conversations have been marginal because of the overbearing dominance of the so-called usual suspects in the field. So these are the intellectual and practical advantages I see in thinking about the global south. And I think, Matya, your idea about using the global south as a temporary placeholder, and if done right, the usefulness of the global south having diminishing value is perhaps the way to think about this. If this diminishes in value, then something has been done right. Thanks.
Perhaps I can jump here in the conversation if there's no other question. There is one now, isn't there?
Hold on, there's one question in the queue. All right, since I dislike people summarizing my Q&As when I submit things in Sky, I'm just going to read the whole thing. All right, so there's a current PhD student at HQ from Mexico, and was a correspondent and assistant researcher for the Global Sales Project, directed by Schweizerberg at Basel. After teaching in Mexico, one of the great problems is the lack of accessibility of sources and primary and academic developments in English, and there's a sheer amount of professors and actors that just don't read English at a professional level. Sources and journals are either in English or too expensive for the universities to fund, which might be a bar for Latin American scholars to engage in the works made by constitutional academics in other jurisdictions. So how can you truly foster north-south academic exchange that's essentially monolingual in construction?
Okay, this is actually going into one point which I wanted to pick up, which Marty also made this point about translations, because I think we are very aware of that, and I wanted to just make 2 points. One is, one is actually indeed the incredible dominance of English, and that's what Guillermo just brought up now in the chat, which is not only felt in Latin America, but for example, surprisingly in Germany. So I very often think that there are sort of academic discussions which are totally sort of on point, but just not available in English, and therefore not part of the sort of the global conversation. And so indeed, I mean, sort of committing more resources to making to providing translations and to making more sort of local discussions or regional discussions accessible to a larger community is imperative. And that's one of the things that we wanted to tackle in the journal, basically, to ask people also to recommend sort of important classic texts from areas that can be then translated into English. I think, it's a long discussion, because I don't think we will get away from English as one lingua franca for all. But I mean, I'm just saying that the dominance of English is really also hindering debate in many respects. And so, yeah, very, very important point. Unless perhaps Google Translations is going to be so fast and so quick soon that we don't even have to do this anymore. But anyway, so this is just one point that I wanted to make. The other point goes into this, is the North closing gates, as Dinesha now puts it, this earlier point. I mean, I think there are different dynamics in different places. So, I mean, Tilburg is probably years ahead, but Germany is still sort of sort of the tendency is still sort of on the rise. So we feel that there is actually an increasing interest in comparative law and also in doing comparative constitutional law or comparative law in general with non-Western jurisdictions. So it's a small field for sure, but it's one where we see a lot of interest also in post-colonial approaches, in critical approaches to doing comparative law. So there I feel the gates are not closing at all, but they are actually very slowly opening, too slowly for our sort of taste, but they are opening. And indeed, this has also to do with what was mentioned earlier, that there is, I think, sort of perhaps again following up on the first contribution, there's a lot that the North can learn from the South, and that this dimension is slowly only dawning in sort of in the circle. So a project that I pursued for many years and still pursue is a comparative project between India and the European Union on actually democracy. And that is fascinating because there India is really the lead jurisdiction, so to say. So it's really more that the Europeans are trying to understand how has that country with 1.2 billion people sort of managed to stay democratic most of the time and peaceful at the same time. And so how do we organize democracy? So in that sense, I think this kind of dimension that there is a selfish interest, as Jed formulated in the beginning, in doing comparative law, including with the Global South, is just sort of coming. At least that's my hope in that regard. And then final point about the constituency. I mean, yes, Dina, I mean, obviously you should call a cat, and you should be clear and talk, for example, about class dimensions and the like. I'm very much with you there. But I think one has to be very careful about context. And so the constituency can be very different in different contexts. So attacking liberalism in Germany is different than attacking liberalism in India. And in that sense, it's a very tricky question. Sort of how do you sort of understand the constituency that you talk to? But I think it's a very important sort of dimension to reflect in what we are doing.
All right, well, we're almost done. I realize part of the prompting, right, is that we were talking about this homogeneity. I speak, from my position as an American, which is the sort of Indian empire. And so the reaction to recent events and the trends happening when it comes to internationalization and stuff are going to be markedly different in different contexts. And I think one of the interesting things is we also are speaking a lot about legal academies, but there's also law-related developments in other disciplines. So for example, a lot of the work that I read has to come from legal history, one of the other fields I work in, where the frame of empire is like resurgent, right? As a frame of explaining all these things that integrate both epistemological, but also material sort of legacies and dynamics that then get spread and reintegrated into other places, right? It's very, I just started reading about all of America's island territories for another project, which is super fascinating, things that are sort of beyond people's sense of belonging, but, in the sense have these types of differences. So I think I'll just sort of wrap things up by saying how terrifically happy I am that this was quite a full and intellectually vibrant discussion. So I guess I'm very pleased with myself. I guess that's a selfish thing to say, that I have invited all of these wonderful people, and I hope to bring you in to other collaborations that we have at HQ, because we don't have representatives from all of your specializations and parts of the world and our own faculty. I think one of the things, the function something like this forum provides, is that you can't within a particular university faculty have all of the potential empirical sort of perspectives that are available. And while you may not be able to hire everyone, right, you can at least be conscious about bringing the best speakers here to sort of fill that gap moving forward too. So it's now exactly 6 o'clock. I thank everyone again for your participation, and I think I'll bring things to a close. Thank you very much.
Thank you so much.
Thank you so much.
Thank you.